Well, welcome to Perspectives, both online and on air. It's from WFSU Public Media, and I'm Tom Flanigan. Thank you so much for joining us. This is our 8th and final program in our series of political perspectives in the lead up to the August 18th primary election in Leon County. And this program was recorded on Tuesday, August 4th for playback both on WFSU FM and our WFSU Public Media Facebook page on Thursday, August the 6th. Today we'll talk with the contenders for Circuit Judge Group 16 in the 2nd Judicial Circuit, which covers Leon, Gadsden, Wakulla, Jefferson, Liberty, and Franklin counties. We'll meet the candidates in just a sec, and each will have a few moments to talk about their background and the unique qualities that they bring to the position. Then we'll get into things such as judicial philosophy and temperament, certainly critical considerations for those who sit on the bench. And the reason we're doing all this is just to give you, the voters, sufficient information so you can make an informed and intelligent decision as to which candidate is likely to do the better job in office. And though we don't get into strict time limits, we do ask our guests to make pithy statements and arguments so we can cover more ground in the course of the conversation. So let's meet our candidates for Group 16, Circuit Judge in Florida's 2nd Judicial Circuit. A pre-show random drawing gave the opening statement nod to the incumbent in the race, who is Angela Dempsey. And go ahead, Judge Dempsey, it is all yours for some introductory comments, and tell us a bit about yourself.
Sure. Thank you so much, Tom, and thank you, WFSU, for putting this on. I'm a longtime member of WFSU. It's a great station, and I'm happy to be here today. So I've been your circuit judge for over 14 years. It'll be 15 years in November. I was appointed in 2005, elected in 2008, and then re-elected without opposition in 2014. I've served in all divisions of the circuit court and resolved thousands of cases fairly and efficiently. I've presided over hundreds of trials, including 12 murder trials. Before becoming a judge, I was a lawyer, of course, and I did litigation for about 12 years. I graduated from University of Florida College of Law with honors, and I have two daughters in their early 20s, one who graduated from Florida last year and one who's going into her senior year at Georgia in Athens. I think I have the maturity, the experience, and the qualifications to be reelected, and I hope you all will vote for me on August 18th.
Thank you very much. Now let's hear from the challenger in the race for some introductory comments. Kevin Alvarez, go ahead, sir.
Thank you so much, Tom, and thank you to WFSU for putting this on. I've grown up on WFSU. In fact, I have a letter from Mr. Rogers from way back in the day when I was about 4 years old. I love watching WFSU, and thank you so much for having me. So I grew up in Ocala, Florida originally, moved up here for law school and for undergrad. I got a double major in criminology and political science at FSU, and then went to law school here. I was able to get both degrees in a little over 4 years. I went right into private practice as soon as I got out of law school, where I practiced high volume litigation, mostly criminal defense for the first 5 years. And then I opened up my own firm, and in my own practice now, I do a mix of civil, some family, and still a little bit of criminal defense. I represent a couple of construction companies as general counsel, where I provide them with advice and suggestions and legal compliance advice on employment issues, and frankly now CARES Act interpretation more than anything else, since that's passed through in dealing with these pandemic issues. With my litigation experience, I've handled hundreds of cases. I've had over 50 jury trials as a first chair lawyer, which is a lot of trials for any lawyer in such a period of time. And I think that makes me uniquely situated to be able to handle the role of a circuit judge. I've practiced in front of every judge in this circuit almost, and almost every judge in the surrounding circuits as well. So I can take bits and pieces from different styles, and I know what works and what doesn't work. And I think I'd be an excellent circuit judge. I have the temperament to do it, and I have the experience to do it.
Thank you, sir. Let's get into some of the nuts and bolts of the actual promulgation of the judge's function, particularly within this circuit, because we are a little bit different from the other circuits that are scattered throughout the state of Florida. More on that to come. But first, Mr. Alvarez, while we're talking to you, certainly for any judicial decision, considerations of law should carry the most weight. Everyone, I think, agrees on that. But a judge's decisions also impact people. Should the potential impact of a ruling that you make on the people who are involved in a case be factored in any way, shape, form, or fashion into the ruling you make?
It depends on whether the law provides to allow that consideration to be made. So sometimes the law can be, and I hate to say cold and heartless, but it can be cold and heartless, where it does not allow the effect that it has on the individual to be considered in the decision making. And in that case, I believe the judge's hands, unfortunately, are tied in that situation, that we have to follow the law whether we agree with it or whether we don't agree with it. There are some decisions, for example, in criminal cases, after somebody has been convicted of a crime or has entered a plea to the judge saying that they're guilty of the offense. The sentencing determination can sometimes take into account the factors of the holistic idea of who this person is and what effect a certain sentence might have on them or on their family and on society as a whole. So in that situation, it is permitted and you're allowed to look at the individual circumstance and the effect that the ruling would have on the individual.
Okay, Angela Dempsey, same question for you. Given that there may be wiggle room in some considerations of law when it comes to personal consideration, what kind of balance do you strike on that, or do you?
Sure, you do look to strike some type of balance. You need to focus on the law and the facts of the case and the evidence that is presented primarily. But then it'll also depend to a large extent on what the other side is requesting. So sometimes the other side of the litigation won't object to maybe delaying a sentencing or delaying a hearing. But if they do object, then you'll just have to weigh the factors. And inevitably, you are going to be ruling against someone in every case. So you do need to follow the law, but you do need to some extent consider how that's going to affect people in the long run, because we do have a large impact on people's lives, our work does.
Let's do something here as far as the administrational side of the ledger is concerned. Then we'll circle back to some other philosophical and more esoteric kinds of fun things that judges get to play with. Angela Dempsey, you folks in the circuit here and across Florida are heading into some rather perilous times, certainly interesting times in the parlance of the ancient Chinese curse. We know what has happened with dockets given the COVID-19 impact. Likely also, as the folks across the street in the legislature start dealing with what are likely to be greatly diminished budgets on a number of angles, including the judiciary, which is funded by the legislature. How do you see that playing out? And if you remain a circuit judge, how does that impact what you do on a day-to-day basis, knowing that you're not possibly going to have the resources that you have been accustomed to?
Right. So the Florida Bar President has described the last 4 or 5 months as a crash course in crisis management. And so we've had to meet this challenge for COVID. So far, nothing really has happened to our budgets, but it has been a challenge to do remote hearings, particularly in criminal. I'm assigned to civil right now. We haven't had quite as many challenges. We can't do jury trials, obviously, and we can't do much on foreclosures. But besides that, we have been able to accomplish a fair amount. I understand that we're going to have less senior judge days, which is kind of a big deal because help us fill in. Like, for example, right now we have 2 open seats, 1 county and 1 circuit court seat, and we're using senior judge days to help out with those vacancies. So I think we're going to be losing some senior judge time. We are short 3 staff attorneys, which is our what people think of as law clerks at an appellate court. So that is a challenge. They help us with a lot of post-judgment and post-conviction work. And also we've been allowing them to work remotely because we're trying to have as few as people in the courthouse as possible. So that's been a challenge. And then hopefully we have those freezes, but hopefully we won't get hit too much worse if they do a special session later this year.
Okay, thank you very much. Kevin Alvarez, for you, this would be a little bit more hypothetical, but let's just say the voters give you the nod, you get embenched, if you will, and suddenly Chief Judge Jonathan Shostrom comes into your chambers and says, Judge Alvarez, we know you bring a fresh approach and a new vision to this whole thing since you're brand new to the job, and I need you to start slashing budgets here for the Second Circuit. What do you do? Where do you start hacking?
So that's an excellent question, and it becomes, as you know, a very complicated balancing test. And in some part, I hate to say it, but this is kind of how our system of government is set up, that resources are limited in each branch of government. And if the legislature wants cases to be resolved quickly and efficiently, they're going to have to fund the resources to have them resolved quickly and efficiently. If they're not going to fund the court system, then as Judge Shostrom would say, all you can do is all you can do to a certain extent. Now, that being said, I think there are a lot of changes that we can make to try to streamline and make it more efficient, especially in the criminal court system. I have a lot of faith in the lawyers that are involved, especially in the criminal court system, to get together and work out cases. There's only a certain number of prosecutors, there's only a certain number of public defenders and private attorneys that are going to be able to actually try those cases. We've seen that the District Court of Appeal and our circuit court judges seem to get along very well from an outsider perspective, that whenever there is a rush on cases, which happens sometimes, and there's this need for trials to be conducted, especially when somebody files what's called demands for speedy trial, that a judge will come down from the District Court of Appeal and sit as a circuit court judge in that capacity to help take the load off the other circuit court judges assigned to the criminal division. So I think the resources of the judiciary, so long as everybody's willing to work hard and make some accommodations, we'll be able to handle that influx and flow. So that's probably what I would tell them. The other thing is that we have to make sure that we make use of these virtual proceedings. A lot of criminal court stuff is case management. Case management is nothing more than scheduling for lawyers. There's no reason that shouldn't be able to take place by phone or by email.
Some questions here for each of you based on some qualification considerations here, if we could. For you, Mr. Alvarez, the very word judge implies good judgment, of course, and you have acknowledged your judgment in regards to some social media posts you made years ago was lacking. How do you convince voters now that those statements don't reflect the person that you are now and they should give you the nod?
Well, I would tell you that the Kevin in his early 20s certainly wouldn't have been qualified to be a circuit court judge, that's for sure. In fact, I would suggest most people in their early 20s would not be qualified to be a circuit court judge. I'm in my 30s now. I'm married. I've been running my own practice. I have employees. I am certainly not the young, arrogant kid that I was when I was in undergrad, when I was in law school, and even in my first year of practice. I apologized for everything that I did back during that time period. And that's why I'd ask the voters to give me a chance. My experience has been people are very forgiving, and I've just been, frankly, overwhelmed by the number of members of the community that have called me and said, hey, push through. It's okay. We all did stupid stuff when we were younger and in our 20s. And so that's what I'd ask voters is to take the time, review my record, and ask people that know me. I think that's the most important way, because as a politician, words don't matter nearly as much as actions. And if you ask lawyers that know me, people that know me, citizens that know me over the past 8-9 years, they're going to say, Kevin definitely has the temperament and the experience to be a judge.
Okay, Angela Dempsey, just as a rejoinder here, your campaign has made kind of an issue out of what Mr. Alvarez said those years ago. Do you think that is still relevant to who he is today, or is this? Do you think the nadir of the whole decision between you two as candidates for the bench?
I do think it's relevant for the voters, and it'll be up to them to decide. But I know some female lawyers discovered the post, and they were very upset by it. And others in the community have been very upset by it, by those posts. And I just think it does speak to my opponent's maturity and his ability to be fair to the groups, meaning women and minorities, that he said derogatory and negative things about.
All right, while we're with you, Ms. Dempsey here, every person, of course, has opinions that fit somewhere on the political spectrum. How would you characterize your opinions, and what role, if any, have they played in the judicial decision-making process that you engage in?
If you mean political opinions, they played no role in my decision-making process. I've only focused on the law and the evidence presented in a case. And so that's why these races are nonpartisan. That's why we're not allowed to say what party we belong to. And it's important that a judge be able to be objective and be able to have independence to make decisions, and then not to be affected by the political winds after that.
Little history, Ms. Dempsey, what do you personally consider to be the most significant judicial decision from any court made during your lifetime, and why?
It's hard to pick just one major one that's affected criminal law in the past 5 or so years is a case called Graham, and it's often referred to with another case called Miller. People just call it Graham Miller. And that those two cases decided that juveniles could not be sentenced to life without the possibility of release at some point. And so now that there's no real parole system in Florida, at least for crimes committed more recently, it's sort of like a parole system for juvenile offenders. And that's changed the landscape a lot for juvenile offenders, who the focus is often more on rehabilitation than punishment for that type of an offender.
Very fine. Mr. Alvarez, any decisions that spring to your mind most immediately that, boy, that was pivotal, that was landmark? I think that meant a lot, at least to you.
So it might get a little academic here, and it's kind of confined to the criminal area, but there's a case called Cable versus State, and what it dealt with is the application of the exclusionary rule to violations of what's called the knock and announce statute. See it on TV when police bang on a door and say, you know, police, we have a warrant, and they wait before they breach the door and make entry. There was a U.S. Supreme Court case called Hudson that said that if the police violate that, the exclusionary rule, i.e. throwing out any evidence that's found, does not apply. And Florida has a constitutional provision that says we interpret the Florida Constitution search and seizure protections in conformity with the United States Supreme Court and their decisions and precedent. Cable is an interesting case because it is a divergence from that constitutional principle. And what it says is Florida has, under a case called Benfield, historically treated the knock and announce situation differently. And so it's a little bit of an interesting enigma in the law that I found pretty interesting. And it had a pretty wide sweeping effect during the time period after Hudson came out, before Cable came out.
Appreciate that. You're watching a special political perspectives from WFSU Public Media. This is Group 16, the two folks who are in contention for the Second Judicial Circuit, Group 16 judgeship, the incumbent, Angela Dempsey, the challenger, Kevin Alvarez. Early voting, in case you noticed, actually got underway this week in Leon County. It continues through the 16th. Early voting locations posted on the Supervisor of Elections website. Primary election day is August 18th, but from what we understand, there has been a virtual tsunami of by mail ballots that have been flooding into Mark Early's office here, and we'll see how everything comes out. Let's go back to some questions here about, again, the uniqueness of the Second Judicial Circuit, because everyone handles criminal and civil cases. That's uniform across the entire state of Florida. But right here across the street from the Capitol, our courthouse has some additional responsibilities. As a judge in this circuit, you may often be called upon to decide the constitutionality of legislation passed by state lawmakers. And almost without exception, the decision you make is likely to be appealed and may be overturned. Now, given precedent and the composition of the appellate court, a savvy judge usually has kind of some suspicions as to whether or not their ruling might be reversed. Should that knowledge have any impact on how you rule? Kevin Alvarez, let's start with you on that one.
So I'll give you a little bit of not a direct response, but best response I can give you. The fear of being reversed should not affect the decision. The fear of not following the law should affect your decision. And so if you're following the law diligently, if you're going through the academic steps you need to reach the ruling, and you know you are correct, then that's what you do. If the appellate court decides later that you were incorrect, well, I'm sorry, occasionally that happens. Not very often, but occasionally it does. But what I think is critically important is that judges have the sense that some of these cases we're going to be dealing with, especially if I'm elected, are going to be very, very serious and have broad sweeping implications throughout the entire state of Florida. And we need to make sure that on especially those cases that have a lot of public attention to them, that we take the time to be super diligent about making sure a good record is created, making sure that we ask the right questions, and making sure that we take the time to inform the citizenry that might be watching the steps that we're taking. You know, a lot of people may be watching in a judicial hearing that have no experience with the law and don't know the nuts and bolts. And I think it's really important when that happens for a judge to take the time to explain exactly how they're getting to the decision that they're reaching so that it has credibility with those that are watching.
Okay, Angela Dempsey, same thing. If you know for sure, you know the folks at the First District Court of Appeal, and you have seen the rulings they have made on similar kinds of items in the past, and you know you're going down. I mean, does that have any influence at all on how you rule?
Yes, and when you're in a civil division here in Tallahassee, which I have been twice, I'm on my second rotation in there, you get a lot of constitutional questions, you get election challenges, and just purely focusing on who's likely to hear the appeal, I think is less important than focusing on the decisions that have come out of that court. And you kind of alluded to that, Tom. I mean, you certainly want to look at all decisions, and especially more recent decisions, particularly, for example, in the election law area, cases change over time. So you want to look at more recent decisions out of the first DCA and how they've been treating those, which of course are binding on us as circuit judges, and make your decision accordingly.
Okay, while we're in your neck of the woods here, without exception, every candidate for a judicial post always says, I will be fair, I will be impartial. What do those words actually mean? Give them some meat and potatoes, if you would, please.
Okay, they mean generally not worrying too much about how people are going to react to the decision. And by that, I don't necessarily mean the parties, but the public or your critics, or anything like that, because we have to focus on the law and not be swayed by public opinion. So that's definitely part of it. The fairness also includes giving people a fair opportunity to be heard and giving them due process that the law requires. And that includes everything from procedural due process, making sure people have adequate notice of hearings and adequate time to prepare, as well as substantive due process, which is more based on the law and based more on substance and the actual arguments that people are making before you. And so that's what those words mean to me.
Okay, and any different connotation for you, Kevin Alvarez, when it comes to those terms?
I think to add a little bit more meat on the bones, I mean, we have the dictionary definition of fair and impartial. We all know generally what that is. In running a courtroom that is fair and impartial, the most important thing is cultivating an environment where people feel like that they're going to get a fair shake, that they're going to have a judge that's going to listen to what they have to say, what evidence they have to present, who's going to be unbiased. And who's not just going to be unbiased, but is going to be on guard for any implicit bias that may creep in at all. And to make sure that then the ruling that they issue is well explained so that generally people watching of reasonable mindset and reasonable education on the issue can say, I see how they got there. Even if they don't agree with the judge's decision, so long as they can say, you know, I reasonably see how he got there. That was a fair shake. That was a fair hearing. I think that's what being a fair and impartial judge is what it's all about.
A new aspect of the judiciary, well, maybe not so new, because I'm thinking back, oh my gosh, I'm going back too many years here. There was a guy by the name of Charlie Minor who used to sit in the Second Judicial Circuit as a judge, a great jurist, also a fantastic playwright. And you would go into his chambers maybe to talk about some point of procedure on a big case that was coming up, and you as a journalist was trying to get some idea of the lay of the land on this, because we're not experts when it comes to this thing. And Judge Minor would very carefully and methodically outline how these sorts of cases would proceed. And then he'd reach down into his desk drawer and pull out his latest screed for a play that he was writing. He wants you to give your opinion of that too. It was always a lot of fun to visit him. But we also had a fellow who has been recently moved up from the county judge level, a fellow by the name of Lane Smith, who was kind of in this boat too when it came to community outreach and explaining what was going on back behind the robes, if you will, of our judiciary, because let's face it, not only journalists, but the average person may not be that up on how our court system operates. So as a jurist, Angela Dempsey, what are your thoughts about maybe getting out more into the hustings? I know we have to do it virtually nowadays, but to let people know just how the courts operate and how they kind of fit into the whole judicial proceeding as citizens, both on the civil and the criminal side of the ledger.
Yeah, community outreach is very important, and I've done that with the Justice Teaching Program. I've done that by speaking at my Rotary, in other ways. I've also done a lot of other community service with Second Harvest and Leadership Tallahassee. But just as far as explaining the legal system to people, when you mentioned Charlie Minor, I don't know, I think there's pitfalls too that can come with that. If you're trying to encourage someone to read your screenplay or buy your book or what have you, there's a lot of pitfalls that can be had with ethical violations. So you want to avoid those also. So I just think you need to do it in a controlled setting, maybe more than in your chambers, maybe in a more formal setting.
Good point. Kevin Alvarez, your thoughts on that, the outreach and the educational dimension?
So, great question. I was thinking about it a couple of days ago when I was reading Lane Smith's column in the paper on probable cause. And I just thought that was an excellent idea, because I think it's really important. You know, with knowledge comes power. And with the number of years that I've been handling litigation, one of the common misconceptions that folks have is that a police officer, when they pull you over on a traffic stop, has to have a reason to ask you to get out of the car. They don't, and that's been settled law for years and years. But a lot of folks just don't know that. So then what happens is when a police officer asks them to step out of the car on a traffic stop, they feel like their rights are being violated. They feel like they're getting slighted just on that interaction, just because they don't know. And when they're in my office and I say, look, they're actually allowed to let you do that, go, oh. And that changes the whole perspective on that entire traffic stop. And I think that's why it's so important for judges to be out there in the community. You know, we can't give legal advice to people, direct legal advice, but explaining how the court system's operating, explaining what they can expect when they enter court, I think is critically important, because that's how the system gains integrity. That's how people have trust in the decisions that the judges make, when they can say, hey, I know Kevin, he's a good guy. And if he ruled against you, it's because you were wrong, not because of any other reason.
Personal ways of handling different cases, of course, are as individualistic as kind of the way that we wear our hair, or you know, choice of colors in the clothes that we wear. But there are judges who insist that they make better decisions if they come, I think the term is, fresh to the case, and don't spend a whole bunch of time poring over things like depositions and other documents before coming into the courtroom. On the other end of the spectrum, however, you have some judges who really get into the minutia. Every single aspect of the case is well known to them, almost memorized, before the trial even gets underway. On that continuum, if we could, Mr. Alvarez, what's your personal approach to preparation before a case?
So I believe you have to be ultra prepared, because a lot of times the arguments are about the nuance. And if you're not prepared on the case itself, you may miss the nuance. And I can't tell you how frustrating that was for me as a lawyer, when I'm coming in arguing the nuance of something, and I'm not able to get the judge to focus on the nuance, because they're caught on an overarching issue that, if they had gone through the transcripts or gone through the evidence presented beforehand, they might have gotten. And so I am a big believer that the judge should be ultra prepared. The judge should research in advance. The judge shouldn't conduct any independent investigation. I think it is critically important for the judge, you know, to have this open, honest conversation with the lawyers. If I've done some legal research, if I'm elected on an issue, I need to come in and bring those cases for the lawyers to say, hey, I read these cases beforehand that might be of issue. Can you all discuss them? As opposed to just keeping that knowledge to myself and not giving them a fair opportunity to rebut them.
Where are you on the perspective, Angela Dempsey, when it comes to preparation?
Sure, thank you. You certainly have to prepare for every hearing and every case, and I spend hours and hours every week doing that. But you also keep in mind, we have hundreds of cases. We have between 800 and 1,000 cases at any one time. So that does temper to some extent our ability to prepare. And then also there's times when lawyers don't get us the materials till a day or two before. And we certainly do our best to get ready. But sometimes, particularly in, honestly, you'll get a 5 or 6 inch binder of case law the day before, and it's pretty much impossible to read all that before the hearing. But preparation is very important.
There are also some changes that are likely to be seen in our courts going forward because of sociological changes. And we have seen what's been going on around the country as far as whether it's Black Lives Matter or some blowback to other things that are going on politically. We have already determined from our conversation today that you try to be as apolitical as you possibly can sitting on the bench, but those things still will make an impact on the courts and the law that you are called upon to interpret in the Second Judicial Circuit. So Angela Dempsey, what are your thoughts on that moving forward? The judge has no, of course, control over those sorts of things, but how do you see that impacting our courtrooms of the future, if you will?
Sure. So we don't have any control over what cases come before us. So we pretty much just wait and see what cases are assigned to us. There has been a body of study that we've had some courses on with the Conference of Circuit Judges, which is the 600 circuit judges in the state. And I'm in charge of putting on criminal courses for that group. It's called being the criminal track leader, and I was selected by my peers to do that. But some of the courses we focused on lately do have to do with bias and implicit bias. And we've had experts come and speak with us, and it's been very helpful.
Okay, Kevin Alvarez, your thoughts on that too, as we head into kind of an uncertain future on some of these issues.
I think that goes to the key of how I want to operate the courtroom. There's a lot of people generally that are watching criminal proceedings. Normally, people with other cases that are set up for their family and friends. And it is so important for a judge to take the time to explain their ruling. I get that judges are busy. I get that there's a lot of cases. But there is nothing more important than explaining the decision that you've reached so that those that are watching will say, I get it. I get how you got there. So that there's not this temptation to say, this judge made this ruling because they are racist. This judge made this ruling because they are sexist. This judge made this ruling because they're unfair. When really it was based on an entirely permissible factor like somebody's extensive criminal history. And so it's really critical for the judge to take the time to explain how they got to where they're going. As to the legislature, the biggest thing that judges have to, I think, be careful about is paying attention to when laws change. Because while it's our job to follow the laws as they change, I think sometimes it's easy for judges, especially that have been there maybe for a while, to get into a rut where their instinct is, well, this is what the law is. And then they don't take the time to diligently look at the change in case law that's happened over the past couple of months because the law was settled in an area for years and years and then changed. So I think judges have to be really careful to listen to the lawyers. And when the lawyer stands up and says, hey, judge, there's this new case out there that says something different than what you originally thought, but they take the time to read it and pull the lawyers aside and go, okay, explain this to me. What happened? What changed? And then to go do the research if they're still unsure.
Second Judicial Circuit, Judge Group 16, the contenders, Angela Dempsey, the incumbent, Kevin Alvarez, the challenger, on our political perspectives. And if you miss all or part of a Perspectives program, it is available online, as is the entire universe nowadays, not only at our WFSU.org website, but also our WFSU Public Media Facebook page. We try to have the latest program up on both places just as quickly as we can after it actually appears for the very first time. In the case of Facebook, it's actually simultaneous with that. How handy is that? Back to the questions, and of course, if you're a guitarist, you have a hero guitarist, whether it's Mike Bloomfield or Eric Clapton or someone like that. If you are a jurist, you probably have a hero judge. And Angela Dempsey, who's your favorite judge, or one that you say, boy, this was the ultimate, this is the pinnacle of judicial conduct and a great mind?
Sure. One judge I really admire is Sandra Day O'Connor, because she was the first female appointed to the U.S. Supreme Court. And I think she did a good job with the reasoning and her opinions at that court.
Who's your hero judge, Kevin Alvarez?
A lot less known, but as a circuit judge, it's Greg Parker over in the Third Circuit. He's just fantastic. I did a trial with him. We had an issue that came up that had some confusion. Me, my client, the prosecutor at the time, him, all went back into chambers, opened up our laptops, jumped on the legal research database. He had snacks and water, was polite and kind to my client throughout the entire trial, was polite and kind to everybody in the courtroom. I just went, and my client said, if the jury comes back guilty, at least that judge was really fair. And I thought that was just slam dunk. That's what we need. That's how we restore integrity to the criminal justice system, is when folks that lose can say, that judge was great. It wasn't because of the judge that I lost. It was because of the facts. It was because the jury disagreed with me, but it wasn't the judge. It wasn't the system.
But you point out something that can be a problem for some jurists, and that is in their attempt to be scrupulously fair. And you can't be friends with the prosecution or the defense attorney or anything else. You have to maintain that distance. But still, we all know of some judges who kind of let things slip through their fingers and the courtroom gets out of control. How do you keep that from happening if you're sitting on the bench, Kevin?
Well, candidly, and I hate to be so crass about it, but there's a bailiff in the criminal court with a gun. There is no question in a well-run courtroom that courtroom can be controlled. And so you have to read through the scenario that you're being presented with. How is everybody acting? Is this in a criminal case, is the defendant somebody that might lose control? And you pay attention to that sort of stuff. And I have a lot of experience doing criminal cases. I think I'm going to have a pretty good read on when somebody is going to lose control. And so then you're careful. Then that's somebody you probably don't bring back into chambers, or you talk to your bailiff and your courtroom security beforehand about how the best way to handle that situation is. But in the hundreds and hundreds and hundreds of cases that I've tried, it is a very, very small minority of folks that don't act appropriately in court. The majority, I'd say at least well in the high 90% of people that I've represented have always behaved well in court with no issues.
Okay, Angela Dempsey, your thoughts on that too?
Sure. So there's a lot of moving parts when you're in the courtroom, from the lawyers, clients, witnesses, bailiffs, clerks. You have to be aware of that, and unexpected things happen, and you have to be ready to address them when those happen. And then, of course, you have jurors, which lays another factor on it. And I know, Tom, you were on a panel of mine one time, and stuff gets brought up, and you have to, make sure you stop jurors or lawyers from bringing inappropriate stuff up, or you're going to have to start the jury selection over again. So it's something that judges really need to be on their toes and be ready for at all times.
And in full disclosure, Kevin, just to let you know, I was tossed out of the jury pool probably, I think, 3 times over the course of my life. They, for whatever reason, neither the defense nor the prosecution really likes to have journalists on a jury panel. I don't know why that is. I'd really like to serve on a jury. Well, folks, as much as we're wrapping up here, boy, could talk to you for the rest of the day. You've all been fascinating here. But as much as any of us may wish to deny it, back to that thing about politics playing a part in deciding who gets to be a judge, if not the actual functioning in the courtroom itself. Because politicians on all sides of the political spectrum have been talking increasingly about the need to have more judges on the bench who reflect a political bent of a certain kind. And it now seems the electorate has really picked up on this as well. So we talk about having judges that should be, good conservatives or liberals or libertarians or something in between, and that if all the judges are the way we want them to be politically, then life will be a wonderful thing. And that this is actually a desired outcome, to have a highly partisan jurist. And I want to revisit, if we could, with you, starting with Angela Dempsey, just your thought on that, because many people now buy into this. We need to have all the judges who fit our political categories across the board. And again, what do you do? Right.
I think that's wrong. I mean, I think you want to have a balanced group. And again, it's nonpartisan. I think some of the best judges, maybe a good example is Terry Lewis. I don't think anybody knows what party he is. And that's how you want it to be. So when you go in there, it's fair, and you don't have a preconceived notion, oh, this judge is a Republican or this judge is a Democrat, so they're going to decide one way or the other. And people try to get you to tell them what party they are when you're running, and you just can't.
Yeah, and Kevin Alvarez, how do you deflect that too? Because of course everyone has opinions and all, but now it seems to be that is what we want. We want all of our judges to think and act a certain way.
I would be scared if we had hyper-partisanship on the circuit court. I truly believe judges have to follow the law, and the law is generally fairly in black and white. I mean, it is what it says that it is. And if you're looking for a judge that has a lean one way or the other, that means somebody might lose even though they followed the law, because the judge doesn't personally agree with the decision that they made. And that's scary. I think that's lawlessness. I understand especially at the higher court levels, the appellate courts and the Supreme Courts, why partisanship is an issue. And in fact, we see in the federal judiciary, it does play a large part in the discussions when we see the confirmation hearings. At the circuit court level, generally a judge is making a factual determination and applying those facts to the law. And partisanship shouldn't have an issue. You should get a fair shake in court, whether you're a Democrat, whether you're a Republican, whether you're a Libertarian, no matter what. And I think if this goes into the lawlessness, if there is a judge who is clearly a Democrat on the bench and a Republican goes in there and loses, the temptation is going to be to blame the judge because they were a Democrat, as opposed to looking at the actual basis for the ruling. And I don't think that's a place we really want to be in as a society. I think that would cause some serious problems. So I agree that these judges' races should be nonpartisan.
Well, which they are, luckily. And there's also, we'll make note of the fact that there is a kind of a parallel process that is going on right now. I just saw it popped up on my feed a little bit ago that we have a judicial nominating commission that is now looking. We have two openings here, the aforementioned Judge Lane, and there's, let's see, one other, Judge Robert, I think, was off. So now the Judicial Nominating Commission is looking to come up with some folks to perhaps succeed them on the bench. And that is a different process completely than the one that we are talking about right now, which is coming up on August 18th, which is the primary election, when both of these folks will be presenting their case to the voters for a final ruling, as it was. And what I want to do is to give each of you, we'll go back to our original order of operation right now for a final couple of minutes. You get to do your summation, if you would. Angela Dempsey, we'll start with you here. Make your best case for why the voters of the Second Judicial Circuit should retain you on the bench.
Sure. Thank you so much, Tom. So I'm supported and recognized as a leader by my colleagues and peers. I've already mentioned my work teaching the other 600 circuit judges in the state. I'm also the chair of the Rules of Criminal Procedure. I was appointed to that position by the president of the Florida Bar, and we write and edit the rules that apply to every criminal case in the state of Florida. I have invaluable judicial experience and maturity that will enable me to continue in this position. I have a lot of community involvement through Rotary, Leadership Tallahassee, and Second Harvest. I'm going to work with Second Harvest later this afternoon through the 25 Women You Need to Know group that I'm also a part of. My opponent, I think, only really has experience in criminal law. He's immature and not experienced enough to be a circuit judge. He's only been practicing for 9 years. There's also only 3 of us 16 circuit judges are women. So I just think that's something to keep in mind when you're voting, and that percentage is a lot lower than the percentage around the state. And the election on August 18th happens to be on the 100th anniversary of women's right to suffrage. So that's kind of an important anniversary as well. And just in anticipation that my opponent might bring up what he normally criticizes me for, which has to do, he alleges that I've been reversed more than other judges. That just is not true. And I have statistics to back that up. But please vote for me on August 18th. I would be humbled to have your support. Thanks so much.
The last word from Angela Dempsey. Kevin Alvarez, it's yours for a summation, sir.
Thank you, Tom. I appreciate it. So I'm asking for everybody's vote on August 18th. My opponent's been a judge now for 14 years, and a recent poll, I guess it was published in the Democrat, indicated that over 80% of people had concerns about whether the criminal justice system was fair, and and that included the court system. I think it's time for a change, because Judge Dempsey has not been able to keep that number lower, candidly. It is of critical importance that judges follow the law and provide an environment that people feel like the rulings are fair and that they are indeed fair. Judge Dempsey is absolutely correct. I normally do bring up her record of a large number of reversals, including 14 times in 18 months on the same area of law. I do not understand how you can claim to be somebody that is careful and scrupulous about following the law and get reversed 14 times in 18 months on the same general area of law. And a reversal is when the appellate court reviews a trial court's decision, a circuit judge's decision, and says that was wrong. And so that's the primary reason that I'm running against my opponent. My opponent, I guess, just alleged that I'm immature, and at 21, 22, 23 years old, I was immature. There's no dispute about that. I've now been married for years. I'm in my 30s. I certainly have the experience. The Constitution requires 5 years of experience for somebody to be a circuit court judge. I have basically 9 years of experience as a lawyer plus a year as a certified legal intern trying cases. So about 10 years of trial court experience, which is plenty of experience to do the job correctly. I'd also note my campaign has chosen not to go negative. We don't think that's appropriate, and we've chosen not to do that. My opponent made a separate decision. So I'd ask the voters to vote for me on August 18th. And thank you, Tom, so much for putting this on and for your listeners taking the time to listen through the race.
Thank you, Kevin Alvarez. Thank you, Angela Dempsey, for being on our final political perspectives before the August 18th primary election. And good luck to both of you in the upcoming perspectives, produced by WFSU Public Media in Tallahassee. Thanks going out to Taylor Cox, Paul Dam, Amy Diaz de la Villegas, Tricia Moynihan, and Lydell Rawls. Our executive producer is Kim Kelling, and I'm Tom Flanigan. As we said, this concludes our primary election political perspectives. We'll kick off another series of programs in advance of the November general election. Seems like it's going to be a long time in the future. It is not. Next week, we're going to return to some non-political topics. This summer marks the 30th anniversary of the ADA, Americans with Disabilities Act. And in Florida and the Capital Region in particular, we got some new initiatives afoot to give the observance some more relevance and significance than in years past. We invite you to join us for that conversation on air and online from WFSU Public Media. Take care.